of you in first of many meaningful discussions. My partner Shallini, Mehra, and I, over the span of 30 years, have sold more than 1,600 rent-stabilized properties. Shallini and I are happy to welcome Alex Fotopoulos to talk about deregulated units.
Hi everyone, we are excited to welcome our guest speaker Alex Fotopoulos, who has been practicing landlord and tenant law since 2014. Alex has a very impressive background. He attended NYU and then went on to Fordham Law School. Alex specifically focuses on rent regulation and has performed due diligence on hundreds of buildings in New York City. In addition, he has defended rent overcharge and regulation cases before the DHCR and the New York State Supreme Court. Amit and I can attest that we've worked on several transactions with Alex and he's helped us get to the finish line. So let's start with the first question. Alex, we find ourselves deep in due diligence with our clients who are buying deregulated units. If you are representing a seller or a buyer, what kind of documentation do you require? Can you walk us through that process? And maybe before that, can you give the audience a brief overview of the HSTPA 2019 rent laws?
Sure, and thank you for having me, Shallini and Amit. HSTPA was enacted on June 14th of 2019, and it was a sea change in the way that rent regulation is administered in New York City and New York State. Prior to the enactment of HSTPA, landlords could deregulate units, which means that they could bring them out of the rent stabilization law through various increases in the rent due to renovations, vacancy increases. After its enactment, the law became draconian. Landlords can no longer deregulate units. Units that haven't already been deregulated are perpetually rent stabilized unless and until the law changes. And that's had an adverse effect on our ability to develop rent rolls. It really leaves landlords in a difficult position. What HSTPA also did was extend the statute of limitations on overcharge complaints from 4 years to 6 years. It arguably extended the look-back period and how to determine a rent. Interestingly, Shallini, the Court of Appeals tempered the Housing Stability and Tenant Protection Act in a case called Regina Metropolitan. Regina was decided in 2020, and it was a landmark case. Regina limited or tempered the legislature's worst instincts, I think. What Regina said was, hey, look, landlords, you can't be held to this new standard retroactively. You can't be punished for following the law as it existed. So what do I look for if you come to me and you're selling a building? On a deregulated unit, what I'm looking for, Shallini, is 4 years of records prior to the registered deregulation. So when you talk about deregulation, that means whenever the unit was registered with the DHCR as deregulated. If that happened to be in 2010, I'd be looking for records from 2006 to 2010. In addition to that, I'd be looking for the last 6 years of rent records as well.
Alex, it's interesting you brought up the 4 and the 6 years period. This comes to a very critical point. Most landlords that we deal with may or may not have great paperwork, especially when you are interpreting it in lieu of the recently enacted rent laws. So that being said, how does a landlord prove that this unit is truly deregulated? It impacts the purchaser, impacts the seller. It impacts the broker. It impacts the price on the asset. So what's your take on that?
So unfortunately, most landlords don't have great records, especially when you're talking about records that go back 15, sometimes 20 years. So I think that you have to get creative if a landlord says, I don't have, or if a seller says, I don't have leases or I don't have, rent records. I think that there's a lot out there that, isn't considered. A rent record isn't just limited to a lease. Rent ledgers are one way of showing a rent. Canceled checks showing rents that were paid are another way. You can look at the DHCR cases by building. You can look at records filed with the Department of Buildings. All of these things shed light on who was in the apartment and what the rent history of an apartment is. And I think in this day and age, it's very important to look at all the information available to you. It's my experience that 9 times out of 10, when you challenge a seller to provide more information, they will, or they can. It's someone just hasn't told them what could
What
be
to look
produced
for.
or what to produce.
Got it.
And that's really the way to maximize, I think, the value of a building.
Then I sort of think that every landlord or seller, especially a seller, should come to experts like yourself. Get that
agree,
building
Amit. I
analyzed.
agree.
Get that building analyzed. So at least you know what the pitfalls in your buildings are, what the pluses and minuses are, and how to be ready in case you want to ever sell the building or even to rent an apartment. I see that thing crop up all the time.
So I think given the draconian laws, I think you're absolutely right. I think certainly, in preparation of sale, it pays to speak to an attorney or an expert in this field, and prepare, be proactive before you put a building on the market. You want to have your paperwork ready, or your due diligence package ready before you send out a contract. You want to have your leases in a Dropbox. I would imagine, you guys selling a lot of properties, want to have a virtual war room, is what a lot of you guys call it, where your leases
We do.
and your renovation documents are all in one place and they're in a centralized location, and you can share them with as many potential buyers as you'd like. And I'll give you an example. I'm working on a portfolio now, and the seller proactively went out and got affidavits from the contractor who performed the work to justify and buttress the records that he already had. And I think that goes a long way in getting a buyer comfortable with the representations made in a contract.
So buyer is one thing, but I'm assuming the courts and the system buys into your concept also?
Yes, there are cases which say that rent records are not just limited to leases. And at the end of the day, Amit, I don't think that there's a bright line rule as to any of this. This is all a big gray area. So, when you talk about our renovations done or individual apartment improvements performed, at the end of the day, one, they need to be performed, and everything else I think is just, a matter of papering properly.
Well, on this subject of individual apartment improvements, aka IAIs, can you talk to us a little about those new rules and regulations? And can you also give us your thoughts on how you think this will play out in 30 years, where we're supposed to claw back these rents?
Sure. So under the current law, it's basically a zero return. A landlord can get up to an $89 a month increase, provided that he spends $15,000 on an improvement. So when you think about spending that much money and getting an $89 return, that's a pretty meager return. The law doesn't recognize that a lot of these older rent-stabilized units have been occupied for many, many, many years by the same tenant, and they're in need of much more significant and substantial renovation. And what I see happening is that landlords have no incentive to really put good housing stock on the market because there's no incentive to renovate these units. I mean, there isn't. And the way that the current law works is that you can spend up to $15,000 over a 15-year period, but that increase, the $89 a month increase in the rent, is clawed back after 30 years. Shallini, I don't know how that's actually going to work out in practice. It's very hard to keep track of increases in the rent that happened 30 years ago. And, when you think about this on a practical level, the guys that are doing it day to day, it's going to be hard 30 years from now to pull that out of the rent. One favorable result, or possible favorable result that I see here, is that the Supreme Court of the United States may step in. There are several challenges that are or were pending to the rent stabilization law. And, if this court's prior decisions as to property rights are any indication, I think that the United States Supreme Court may temper some of what's been enacted already.
I hope so.
Alex, we hope so, and we share your optimism that the Supreme Court should step in. Talking to experts like you and talking to other landlords, one door that I believe is left open is setting the rents on new units. Can you explain, for the benefit of our audience, especially the landlords, what does that mean, setting the high rent on a new unit?
Sure. New unit creation or unit combination allows a landlord to set a first market rent that's subject to rent stabilization. So in order to be able to set a first rent, it's a two-part test. You have to significantly change the outer perimeter of an apartment. So You have to add or subtract a significant amount of square footage. And
What's a significant amount?
you're not going to pin me down, Amit.
Of course
but
I am.
would say at least 80 square feet or 10% of the existing apartment's square footage. I think that, these are not bright line rules, right?
Okay.
So the DHCR will look at this, we'll look at the totality of the circumstances. And the second part is reconfiguring the interior of the unit so that the prior unit no longer exists. That might mean taking a 1-bedroom and making it a 3-bedroom, or taking a studio and making it a 2-bedroom. But what that allows you to do, at least today, is set a first rent that's subject to rent stabilization. There are certain riders and registrations that need to be done in conjunction.
There's always a catch.
There's always a catch. I think that your ability to do this will be limited. You're going to be up against a clock. I expect that either the legislature or the DHCR will be amending the rent stabilization law or code to limit a landlord's ability to develop the rent roll in this way.
That's not good news.
That's not good news. It's very bad news for us, actually.
Okay, but moving on to a positive note, because our city has successfully weathered many storms, what positive signs do you see, and what are your final words of wisdom for us?
Well, Shallini, I don't see how it can get much worse than where we're at. I mean, there's an eviction moratorium through January 15th, if I'm not mistaken. There's no deregulation, and the maximum amount of dollars that you can raise your monthly rent is $89 on a vacancy. But on the upside, for the first time in almost 10 years, we're going to have a new mayor, and I'm hopeful that it'll be a better environment for real estate developers and landlords. Because I find most of my clients want to do right. They want to put good housing stock on the market, but they want to turn a profit. And I hope that we'll be in a better situation once the new administration takes over to do so. So that's the good news, Shallini. But the one piece of advice that I have for landlords is that they should save every single piece of paper that they have in connection with their buildings. Canceled checks, leases, rent ledgers. You never know what's going to be the difference between proving a rent or proving a deregulation and getting stuck with a rent stabilized unit. Definitely hoard, definitely be a pack rat, and keep everything, because one day you will need it.
Alex, again, thank you for the insight. We are also optimistic, and because we are so optimistic, I have to tell everyone that Meridian is probably going to outperform the last year's projections of doing almost $40-something billion. And we forge ahead, and we hope we can invite more guests on this show to talk about this intricate laws. And Alex, you're more than welcome back again.
Thank you, Amit. Thank you, Shallini. It was a
Thank you,
pleasure.
Alex, for coming in.
Thank you.